Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Big it up. Oh na 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 na. Big it up. Oh na 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 na. Bam bam. Bir bam bam bir bam bir de. Bir bam bam. Bir bam bir de. Bir bam bam bir bam bam bir bam bir de. Bir bam bam. Bir bam bir bam 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 bam. Bir bam bir de.
Good morning, everyone. Welcome to Home and Away Jamaica, where we connect Jamaica and the diaspora. It's your host, Robert Taylor, attorney at law. Happy to be with you today. And in fact, I'm the special guest. So I will be running the show solo. And for today's show, I'm going to be answering two questions that were sent in by listeners. So without further ado, let me go straight to the question. My deceased father had land in Glasgow, St. Anne, Jamaica, which was bequeathed to him by his late father. We left Jamaica many years ago and our cousins were taking care of the land. However, since his death, presumably my father's death, the land tax was not paid, and I have currently paid all the land tax that was due. The land tax was in my grandfather's name. I do not hold a copy of any title deeds, but according to my mother, the land was left to my father. I do not think that the land is fenced and it may still be unoccupied. However, there could be someone living on the land. Could you advise on the following? So the first question is, how do I find out where to get a copy of the title deeds, please? So first, in answering this question, we are making a presumption that this is registered land. If it is registered land, then on the property tax receipt, there should be a land valuation number that we can cross-reference with the titles office and obtain the volume and folio number, which are the title references. And from that, we will be able to pull a copy of the title. However, if this is not registered title, then it poses some other issues, which we can get into before we wrap up the other questions. How long can a piece of land remain unoccupied before someone can claim adverse possession? So I would imagine that the viewer, her concern is that the land is unoccupied or not occupied by anyone that she may know. And the concern is whether someone can claim an interest by way of adverse possession, since for the most part, this family seems to be away from Jamaica. The period for adverse possession, we've discussed in some of our other programs, is an uninterrupted period of 12 years. So in this instance, there would have to be an uninterrupted period of 12 years for someone to start the process of applying for adverse possession. So as we've said before, uninterrupted period of possession in of itself does not grant a person a right to adverse possession. It's just one of many things that have to be proved in an application for adverse possession. The third question, once I'm able to find the title deeds, what are the steps of getting the land surveyor or getting the land surveyed? I'm sorry. So again, the presumption is that this is registered land. Now, if for some reason we determine by way of the cross-reference to the land valuation number that there is a volume and folio number, we can get online from the National Land Agency a scanned copy of the original title that the National Land Agency has in their possession. Recall, and we've discussed before, that the actual title that owners have in their possession are duplicate. They're actually copies of the original that's kept in the custody of the National Land Agency. So we can get a scanned copy online, and that's a scanned copy of the original that's being held in the custody of the registrar of titles. Now, if you need to deal in the land, you will need the duplicate certificate. And what would have to be done is an application for lost title. So if for some reason no one can locate the duplicate certificate of title, an application for lost title would have to be filed. You'd have to indicate how the title was lost and make a formal application. To survey the land surveyor, you would just need to identify a commissioned land surveyor. And what he would do is, using the volume and folio number, he would retrieve the title and any plan, that's the drawing that would be attached to the title, which determines the boundaries and the layout of the land. He would retrieve that as well from the National Land Agency. Now, not sure the context of this question, but getting the land surveyed may not be necessary if you're selling the land, if you're not making an application for adverse possession. So if you're selling the land, it's usually the responsibility of the person purchasing as part of their due diligence steps to undertake the engagement of a land surveyor for a land survey. The fourth question, time's running very quickly. What other documents does my family need to ensure that we are the legal owners? So again, we're going on the presumption that this is registered land and there is a registered title. So if there is registered title, as we said in the answer to the previous question, that title can't be located, then the estate or some representative of the person whose name the title is in, and in this case, the grandfather, would make an application for lost title. Once that application is approved, a new duplicate certificate of title would be issued in the name of the last registered owner. So in this case, it would be the grandfather whose name would be registered on title. If we were to sell the land, what would be the process? That's the final question. Again, we're working on the presumption that this is registered land, and there is, presumably, if we need to file an application for lost title, that we at some point will have in our possession, usually about 45 to 90 days, we would have the duplicate certificate of title in our possession. Now, once we have the duplicate certificate of title in our possession, there are some other steps that need to be executed. So presumably, this title would remain in the grandfather's possession. If the land was left to her father, that's her grandfather's son, and I'm presuming this person is a she, so I'm saying she, then a probate application would have to be done, assuming there was a will. And so if the grandfather had a will, then probate would have to be done to probate the land to her father. Her father presumably would need to have had a will for the probate to be done, conveying or bequeathing that land from her father to herself and her siblings, if there are siblings. If her father did not leave a will, then we would have to proceed by way of letters of administration, which sets out the related persons who can benefit from this land being passed on to them. We're also assuming that the grandfather had a will. If the grandfather did not have a will, then we would do letters of administration, and the land would pass to those surviving relatives. It may be if the grandfather had siblings, if he had children, if he had a spouse that survives, but whoever survives, there is a formula under the law related to letters of administration, which sets out who can benefit. So on one side, we're making certain presumptions that there is registered title, that there is a will that the grandfather had in place, bequeathing that land to his son, and the son in turn would need to, by will, bequeath that land to his children. If that's not in place, we're looking at proceeding by way of letters of administration. There's one other possibility, and that possibility is bypassing all of the standard means of bequeathing land generationally by way of will, and that is possibly doing an application for adverse possession. And in that way, you would skip over or bypass those other processes which could prove to be time consuming. And so we could look at that. Now, if there is no registered title, we would also need to look at bringing this land to what we call first registration. Now, for those viewers who have been following our programs, we had one of the senior directors, Shalise Porcius, from the National Land Agency back in January. And the National Land Agency has embarked on a program of expediting, in particular areas in Jamaica, unregistered land and moving them to registered land. And so my suggestion would be to contact the National Land Agency, find out if this area, Glasgow, St. Anne, falls within one of those zones or territories that are being focused on for expediting adverse possession, not adverse possession, registered title. And so that would be the first step. Moving to get the land to first registration, and then looking at the most practical route in passing that interest from the grandfather to the surviving beneficiaries. That may be by way of double probate, doing the grandfather's, probating the grandfather's will, and also whether it is letters of administration or probate from the father to the beneficiaries of the father. So a lot to digest. The good thing is you can always play back this program and go over some of the advice given. We should have time for one final question. So someone has asked, what happens if there is a change of terms or details in an agreement for sale or tenancy, which the purchaser or tenant did not agree to, but they are expected to agree? So the first thing we'll look at is the agreement for sale. So this person has asked, what happens if there is an agreement for sale of land and the person selling, the vendor, has changed a term without the consent of the person purchasing? So the first thing is all agreements for the sale of land must be reduced to writing. So there's no legally binding contract that can be determined or engaged unless that contract is in writing. So if both parties have agreed to terms, that contract is not binding until a deposit is made, the person purchasing signs, and then the person selling signs. Then you have a legally binding agreement. The person purchasing ought not to sign that agreement until they're comfortable with all of the written terms. If the person selling proposes to change a term, that would have to be done by way of an addendum to that agreement, and both parties, the seller and the purchaser, would have to agree. In relation to the second question, this person has asked what happens in a tenancy. So this is a landlord-tenant arrangement where presumably it's not been reduced to writing, and one of the verbally agreed terms has been changed, or a new term is being introduced. So again, what I would recommend is for any dealing in land, whether it's a purchase or a landlord tenancy agreement, have it reduced to writing so that there is no ambiguity. If there is, then the person in the weaker position will generally be left at a disadvantage, which could be the case in this situation. So if there's nothing in writing, there is just a verbal agreement. We have to rely on the common law principles, what occurs and what has been determined by way of previously decided cases. So without further information or facts on this particular issue, it's a little difficult to advise. But if it is someone is in tenancy and the landlord introduces a new agreement that works adversely to the tenant, it's not unlikely that that landlord may be within their right to give notice. Chances are this would be a monthly tenancy because there's no agreement as it relates to a long-term tenancy. The tenant, on the other hand, if it is something that is outside of the law and egregious, could bring an action and a claim against the tenant in court. Again, costly, inefficient. So my advice is make sure any agreement, whether it's land or any other commercial transaction, you reduce that agreement to writing. So we've gone through quite a lot. Thanks again. We're going to wrap up. Until next time, from me, Robert Taylor, Home and Away Jamaica, where we connect Jamaica and the diaspora. Be safe. Goodbye.
TV, bam bam, on the street, bam bam.